let's at least open and see whether you people can wrap it up within a reasonable time. You can wrap it up within, what you would suggest, Mr. Solicitor, if some meeting can be held between, say, you, Mr. Venkatraman, and the...
I will take the responsibility, Manoj.
If you all sit together in a little bit of a case management conference.
We shall do that.
And between the lawyers appearing for the airports, if you can focus on who is going to argue what, so then there's no overlap on submissions.
They can have a separate independent meeting, Manoj.
Right.
And for general, we will sit, Manoj. I'll invest
a general meeting so that, in half an hour, you'll be able to, sort of sort out, which are the key issues which we have to decide. And the substantial questions of law, if all of you can sit down together and formulate. Because why should we spend half an hour formulating the substantial questions? At least that the lawyers should be able to do.
I don't see any difficulty, Manoj. We will be able to do. We can have joint.
But you will also be appearing in that? We are hoping that they can put things together themselves.
Direct listing on Tuesday, so it
will
be on the list on Tuesday.
Yes.
May have your lordships leave public
there are
service.
Some unserved respondents, technically.
Well,
Union of India is the unserved respondent. Your lordships, say, Mr. Maroria would file his appearance, so that it's not shown as unserved.
The Solicitor General states that list on so and so. Solicitor General
Federation of Indian Airlines, you may have to.
That Mr. Maroria, for the Union of India, would file an appearance on behalf of all unserved parties within the within the Union of India.
Yes.
This relates to the Telangana Public Service Commission Group 1 examinations. Those examinations took place. We filed a writ petition. What they're doing there is that when an SC, ST or a backward candidate is appearing for the examination and he competes in the general category and succeeds in the general category, they don't consider him in the general category. And they keep him under 50%. So that those people, it's a fresh matter. The judgment was rendered on 16th, uploaded on 17th. We came to this court, filed the petition, and the result, and on 21st.
Pick it up on Monday.
But 21st itself, they have to sit for the next examination.
We'll take it up on Monday now.
Monday, let it be high up because otherwise.
And we'll also have the benefit of reading the judgment of the review.
But may I listed an advanced list of.
Mr. Solicitor, Mr. Attorney, you want to mention something?
Yeah, your lordship recollect the DMRC matter. Yes. And after the judgment, we have been struggling very hard to get our money back. We have filed a contempt application quite about a month and 2 ago. Like if it's possible to have the contempt listed.
Are you here?
I sent request to your lordships earlier.
Are you here next week, Mr. Attorney?
I'm traveling for the whole of next week, your lordships.
So we keep it after Diwali immediately.
Very well. Great.
Lord, may I mention two matters, Lord? One is that Armed Forces Tribunal, Lord Chandrachud bench, your lordship will recall that notices had been issued and we had written that email also. And Lord, that CAG appointment matter also.
No difficulty.
And the CAG appointment matter also, Lord. There also I've sent a personal email to your lordship personal account.
Just send an email. You can.
I've sent.
I'll just examine it in the afternoon.
May I mention again the DRC matter, Manoj? Your lordships had appointed in DRC interim chairman Justice Jayant Nath, Manoj. And the order was that it has to be until the Constitution bench matter is decided.
Right.
However, there's a statutory provision which says that the chairperson must demit office at age of 65. That is happening on 10th of November. So, Manoj, we have moved an IA for appropriate clarification so that your lordships will clarify the position. Kindly have it next week, Manoj.
May I?
I'm so grateful.
Civil appeal. May I kindly mention the Unitech matter? I'm mentioning for a very limited purpose, sir. What has happened is that some people have come into the project site. They have stalled all the construction. They say that Noida has not settled their dues since 2008. Whereas
All right, just remind me.
Let's-
So only, is there an MA by the government appointed board of directors, or what is it? Or is it an IA, or what is it?
Please, Malas, in fact, we've just moved a mentioning to say, Malas, let it be
But
taken.
Anubhav, you'll have to move some
Malas,
application.
we'll move, Malas.
Huh? Then just move the application and mention then on Monday.
Lord, civil appeal listed on Monday. Mention before your Lord.
Talk to Mr. Venkatraman, ALG, and he'll guide you on what kind of IA to file, etc.
Please, Malas.
Lord, civil appeal listed on Monday in the advance list 21st. My Lord directed it not to be deleted. It is now deleted. Would your Lordship direct it to be in the supplement?
Supplementary, he says.
Lord, I checked up. They want a direction. Otherwise,
No,
they're saying.
he'll take those directions.
May
I mention diary number 4849?
With the fresh matters?
matter.
All right, fresh matters, can it wait until next week?
If it could come up on Monday.
What is the urgency?
I'll tell you.
When was the impugned order passed?
The impugned order was passed on 16th, not uploaded. The CAT order was passed on 15th, not uploaded. I've come
15th of which month?
this month, Lord, day before yesterday and the day before that.
And what is the impact of the
The
order?
impact is I am presently a serving officer in Andhra Pradesh. I have been asked to go to Telangana where I have no posting. Here, I am in the DM.
All right.
Yes.
Manoj, if I can mention,
I'll assign a regular bench.
if I can mention the
Monday,
writ petitions.
I'll talk. Yes, I've already told him. He just take instructions for the bench, that's all. So you don't have to go before a service bench. Yes.
Manoj, the writ petitions concerning the displaced Manipur students is still pending, Manoj. It was last listed on August, but till date it hasn't been listed again. Manoj,
Displaced Manipur school.
Manoj,
Next week we'll list it.
next week, Manoj. Monday, Manoj.
I'll try and keep it on Wednesday instead of Monday. Monday's board is already heavy, you know.
Can it be at top of the board at least, Manoj? Because
The reason I kept it on Wednesday is that there'll be only one or two fresh matters.
Um,
We'll do it at 10:30 in the morning.
right. Grateful.
Something which you, without your saying, I know what to do. So that's why I kept it on Wednesday.
Permission, my lords, I am mentioning, my lords, SLP civil number 9388.
Fresh matter?
My lord, after notice matter, my lords.
Then circulate an email. What is
I've
your?
circulated
Well, I'll pass an order.
After notice matter, I may mention.
Circulate an
Lord, I have done it. Lord, but
Then I'll take a call on it.
My lord,
When did you circulate the?
my lord, it has been deleted on 4 occasions. My lord, last,
The latest, when did you circulate?
my lord, last was on 14th. My lord directed it to be listed on 21st. On 21st, now the list is out. The matter is not in the list, and it is happening for the 4th time. My lord, 2nd August,
Which
30th
is the
September,
assigned bench?
14th October, and 21st.
Which is the assigned bench?
My lord's bench.
Let's check the look. Yeah. All right.
Obliged.
Permission, Milord, there's a contempt petition, Milord. Milord, I mentioned it for today. It was directed not to be deleted. It has not come up in the list. My issue is there is an observation by another predecessor, another bench which says that both the parties are trying to interpret the judgment, and the original judgment was pronounced
Which bench does it pertain to?
by Your Lordship and Justice Hima Kohli. Milord, Justice Hima Kohli is now demitted of
All right, we'll just check.
next week.
My lords, this is a matter of violence against Christians, which was heard at length by your lordships. It was listed for final.
These are all after notice matters. Just circulate it. If it's time, if it's
My lords,
possible,
notices
we
have
have to
been issued in this matter, but rejoinders have been filed.
Fair enough, we will list the matter.
For final
We
disposal.
list it, but it can't be done. There's no real urgency.
My lord, my matter shows it today's, my lord, as a sanitary paid matter, my lord. My lord, it's already fixed in September. There is a tentative matter shows in.
My lords, if I may just mention.
Yes,
My lords, if I may just mention, there is a continuing violence happening and an additional application is also.
Ma'am, I'll list it. Don't worry, I'll list it.
It's MA number 930/2022.
MA will be processed by the registry. MAs will process first by the registry.
My lords, I have already.
They look at maintainability. Let the registry look at the MA.
My lords, it's after notice matter. My lords,
All right, we'll deal with
urgency
it.
is on 21st. My lords, even regarding the.
MA means what? In a disposal of matter, somebody files an MA. What is the MA for?
It is regarding the clarification of the order, my lords.
Nothing. Yes.
My lords, even I have mentioned before, my lords, on 15th of October, my lords.
Will be. Chalo, follow item number 1.
Lordship, may I submit something?
No. You can't come every day, ma'am.
Lordship, I want to show you some document which is caps of this matter. If Lordship have a look, then it would be eye opener to the.
Ma'am, your curative has been dismissed.
Yes. Yeah,
After that, you filed a writ.
No.
You have filed a writ petition.
Yes, but
And the writ petition has been lodged.
why lodge? Because this is criminal petitions and there is no
After,
bar
ma'am,
after
I
dismissal
can
of
ask that question. After a curative has been dismissed, you can't file a writ petition.
writ petition, criminal, not civil, sir.
Makes no difference. You file an appeal against the lodgement order.
Yes, I file appeal, but
Will be listed.
as Sam said that they are not going to list the matter.
Your appeal will be listed against the lodgement.
Okay, accept. Lordship.
Now, don't take further time. You have made your point. Yes.
My lords, even I have mailed my lords.
MA will examine what the MA is.
My lords, has been.
I will not give a date on an MA right like this. I want to first know what the MA is about. Otherwise, MAs are a gross abuse of the process. Let us first find out what the MA is, and then I'll take a call.
My lords,
So please,
there is urgent.
we have to get everybody. That's why you're mentioning. But we have to first see about the maintainability of the proceeding. This MA business has become now completely an abuse of the process.
My lords, it's from 16th of October. It is struck in listing branch, my lords.
Lordship, I want to show you one document.
No, ma'am. Thank you. When the matter is listed against the appeal against the lodgement of your writ, you can argue the matter.
Whatever your registry official inform you, it's completely different. This matter is completely different from.
Your curative has been dismissed.
Of course.
1 second. Your writ petition under 32 has been lodged.
Yes.
Yes.
Why is lost? This is my.
I have to argue when the matter is listed, not like this at mentioning. You may have a point.
Not want to list this matter soon because
they will, ma'am. They will list the appeal before the appropriate bench. They will list your appeal against the lodgement of the
list matter soon. So that
obviously because they are harassed by people like you, because there is a curative which has been filed. You've paid in all your everything has attained finality.
Petitioner, she is not harassed by.
Second one.
Your Lordship, this is relating to the question of Section 21(5) of the NIA Act, Your Lordship.
Three 27 days in filing the SLP.
Yes, Your Lordship, but the SLP criminal 5 to 29 of 24.
What is how do you explain the delay?
Your Lordship, he has.
This is done delay.
Your Lordship, I was just. Your Lordship,
sorry.
On the question of mandatory versus directory, Your Lordship has issued.
But not in every matter. You have to come within limitation.
Your Lordship, only when the notice was issued in a related matter
that you can't say that because notice was issued somewhere else. Therefore, I realized I should file.
But since this.
Thank you. Item 1, dismissment delay. Item 2.
Lord, this is that matter, Lord, of habeas corpus relating to an ashram, Lord, Your Lordship recalls.
We had asked for the report, right?
We filed the report.
We have filed a report.
Yes.
Your Lordship said spoken in chamber on video conferencing to those two. Even Your Lordship might recall, Lord. So, Lord, the report also says they have again recorded, Lord, the statements of those two women.
But there are two things I must point out.
We have not studied the report. Can we keep it on Monday so we have an
Lordship, we keep it on Monday. Lord, my idea is, our anxiety is to close it at the earliest because what has happened is, Lord, after the report is filed, people are picking out, Lord, parts of this annexure and it's all over the media. Somebody has his own axe to grind against the institute. Somebody has an axe to grind against Sadhguru. Somebody has to say something. Privacy rights, Lord, are being violated. All this is happening. But anyway, keep it on Monday, Lord.
Their privacy would be violated.
Lord, tens of statements have been recorded from media.
Let that not go in.
Published any further?
Yes, Mr. Dukhan.
Some foreigner statements are recorded. All statements say that we are our own volition.
The privacy also needs to be respected.
We'll see what the report says.
Point out two things, Lord.
You have a.
Lord, he is the father.
You have a lawyer here? He's here, right? So then allow him to argue. No difficulty. He's a party in person. You never get angry with that. No problem. He's here. You have a lawyer here.
May I just take 2 minutes?
Unfortunately, the daughters are very critical about the father in the report also. They were critical when the Lordship heard. They are critical again. I don't want to comment on that.
Lord, may I just take 2 minutes?
They can show that the report is small, report is not large.
Just read this. This is on the father.
Lord, may I just take 2 minutes now before your
Lord, put your Lordship. 1 second, please. Kindly first see para 25, Lord, of this report.
Page 19.
Page 19. Page 19. In fact, if your Lordship sees page 18. Page 18. Para 24. So the report talks about phone calls between the parents and the two daughters. So many calls between these years. Then your Lordship turn the page to page 19. So many seconds, etc., etc. Now 25. In reply, the said two ladies stated they are living happily in the ashram. They have requested their parents not to tell lies about them, institution, public not to disturb their path. Petitioners do not show care to request continue to humiliate in public, but so-and-so confirmed she did not skip her meals. She's not fasting to death. She confirmed she told her sister to inform the petitioner she would go on fasting to restrain him, that is the father, from making false statements public about them and the path of monkhood in the institution. Next week. Further, so-and-so have stated they are meeting their parents often. Their relationship was fine. Even the said two daughters met their parents in June on the occasion of their anniversary, in the circumstances so-and-so. Their father accompanied the persons who tried to get inside the ashram so-and-so. Agreed by the attitude of the father the very next day. So-and-so called his father, told him he should give up his legal protest against the center. And so-and-so until otherwise they will do this. After that, relationships went sore and they resulted in filing of the writ petition, etc. So this is not what the police is now saying. So this matter should be closed now.
Can I just
not like this now?
Well, I did not want to get into these details since they have decided to.
I have done nothing against the state.
May I just point out? Your Lordship not curtailed the inquiry. So whatever we had done till that date, we've only provided that information. Now, Lord, there are two things which I must bring to your Lordship's notice.
Mr. Gupta, you'll only point out one thing. You're such a seasoned senior lawyer yourself. But a habeas corpus petition is filed by the father. He's entitled to file it. It appears that 8 years ago, the mother had filed a habeas corpus petition. Now, this time the father filed the habeas corpus petition. Will not stand on any technicality because after all, he's the father of the two children. The High Court called for the two, not the two children, but the two women to appear before the High Court. They both of them expressed their desire before the High Court, what they want to do. Now, after that, High Court said that, well, the police should conduct an inquiry, etc. Now, we called for when the matter was before us, we spoke to the two individuals. And we have recorded in our earlier order what they said. Now, both of them have said that, look, we are living there out of our own free will. We speak to our parents. They have said that we are allowed to leave. We go out whenever we want to. She, in fact, participate in a 10-kilometer marathon. They are adults. They have made voluntary statements. Now, within the framework of a habeas corpus petition, we have to close the habeas corpus.
No, I was something else. I was on something else, which your Lordship, my learned friends preempted me. Perhaps what I would have said may not have harmed them. That's what I was trying to point out.
Right.
But would your Lordship just come to, I want your Lordship to say two parts to the matter, Lord. Please come to page 709.
709.
In fact, Lord, your Lordship may begin at annexure 11, page 705. Annexure 11, 705, you'll see we have put photographs of them meeting. So it's not that, not the state is taking, not the state, and two things, my Lord, we need to get very clear. And not, it's a matter of fact, we place that. But there is something, Lord, which I want to just clarify, Lord, so there should be no impact on that by your Lordship. Because please see two things, Lord. Please come to the, now your Lordship seen that 705, sorry, 706, 707, 708, 709, not a problem. Lordship seen all of that, 7110.
The parents with the
parents meet. So not we place that on record. Now, just two things.
Mr. Luthra, please rest assured.
No,
we are not going to make any adverse observation about this.
My Lord, there are two things. No, Lord, there's two things I need to clarify. So, Lord, there should be no gap. And it's my duty as not as an officer of your Lordship's court to clarify it. Now come to my status report for a moment. Now, Lord, please come to para number 8. Because there were two parts to the impugned order. One was regarding the court for whatever reason, Lord, asked us to look into other cases that were pending. Yes. Now, please come to para 8, Lord. I'll just not point it out to your Lordship. I don't want to necessarily read it, Lord, because that would be not.
Can we even read it by ourselves?
Why not we just see para 8?
Just give us a moment. That's
Page 5.
Page 5.
Yeah.
Page 5 para. Para 7 onwards, you may read it. Para 7, para 8, just note, Lord, last about 8 lines further in the past 15 years. Lordship seen that? Now, please come then to para 9, my Lord. There is a writ petition pending. We place that as a matter of fact because there was an issue of a crematorium being run in the premises, but that's a matter of the High Court, Lord, not to your Lordship to be disturbed with. Then, Lord, please note the paras page 6 bottom, case under POXO Act. Please see that. Now, this is pending. Then page 8. But Lord, please come to page 9 bottom. Page 9, subsequently, your Lordship's got that. See the last line, however, on perusal. Just see that, those language. Lordship's got that?
Just 1 second.
8, Lord, please see 8.
The original reputation has nothing into a roving inquiry. Say that these are the cases which are.
Just see all of page 8.
We look into it.
Page 8, the details of the case.
To see page 8 bottom, my Lord. This was a problem between
Sir, just a minute. I'm just pointing
participants.
out. I'm just, Mr. Rup,
And
please allow me.
then on page 9 top.
Let us look fine.
But as I said, Lord, that's the reason I'm being very sensitive not to read this out because I'm conscious of my responsibility.
Mr. Surutra, please.
Yes, now please read Lord, page 9, the last 8 lines, however, on perusal of the CD file.
Where are you now?
Lord, page 9, please come to the 4th line from the top. However, on perusal of the CD file, it was observed that the statement, Lord, now, that's the statutory requirement of 164, Lord. So, Lord, for that, we are opening it. Lord, please note, other cases, kindly just note that. So, Lord, this is the position as it exists. Now, Lord, there are 2 more things which I must, of course, point out. We had a limited inquiry. That's all, Lord. So that's not the issue. Now, just one more thing, Lord, which my Lord we want to just consider because I understand that's a matter of some concern. Lord, para 15. Just read para 15 at page number 13. Sir. I further submit, Your Lordship have that, I further submit that on behalf of the Social Welfare Department, so and so have submitted their report. In their report, they've inquired total 45 students and from Isha Home School, Sanskriti, they opined there is a need for awareness programs about child helpline, children's rights, etc. Then 16, I further submit that the psychiatrists who were part of the team submitted their report by observing, please read that part. Then Lord, para 17. Seventeen is important, Lord. You can't run an X-ray machine without a license from the nuclear authority, Lord. Just read para 18, Lord.
Mr. Luthra.
Yes, my Lord.
You appear for the state.
Yes, ma'am.
Whatever you have pointed out,
yes, ma'am.
As a state, you are expected to proceed in accordance with law.
That's all. That's all.
Just
It should not be.
Sorry, please.
Yeah.
Whatever you have pointed
18
out,
and 19.
as a law officer, we appreciate it.
Yes,
as an officer of the court. Who stops you from doing all this? It's your duty.
Yes.
We are today only concerned with an order which was passed by the High Court in a habeas corpus petition where statements were recorded of the 2 corpus. At the end of that, High Court should have closed the matter. Instead, High Court proceeded. That exceeded when the jurisdiction of the High Court. Only thing is, whatever you have pointed out, it is expected of you to look into it in accordance with law.
Yes, Lord. 18 and 19, Lord. That's why I just pointed out, Lord, I started by beginning to say that the young ladies had made their statements. We pointed out those photographs, but para 18 and 19, Lord, those, our rights should be protected. Lord, that's the only concern. Yeah, just a minute.
Lord, may I make a submission? Lord, may I just make a short submission? Lord, in a habeas corpus, all this, Lord, what the High Court doing is unwarranted. Lord, it affects our institute, lakhs of followers, our privacy.
The proceedings before this court and Article 136 of the Constitution arose from an order of the division bench of the High Court of Judicature at Madras, from an order dated 30 September 2024 of a division bench of the High Court of Judicature at Madras in a petition seeking a writ of habeas corpus. Stop. The background of the antecedent facts which led to the initiation of the proceedings under Article 136 have been adverted to in the order of this court dated 3 October 2024. Stop. For convenience of reference, the entirety of the order is reproduced below. I think instead of dictating,
Yes, Your Lordship.
instead of dictating the whole thing again, we'll just refer to our order. Huh?
Yes.
In pursuance of the order dated, in pursuance of the order of this court dated 3 October 2024, a status report has been filed by Sri K. Karthikeyan, Superintendent of Police, in charge of Superintendent of Police of Coimbatore District in the state of Tamil Nadu. Full stop. Essentially, the petition before the High Court was moved by which respondent, Mr. Luthra?
Respondent number one.
First respondent.
R1.
R1, Lord. They seem
First
to have
respondent,
counter also.
who sought the protection of his daughters, Geeta Kamraj and Lata Kamraj, who according to him were held captive inside the premises of the Isha Foundation at Coimbatore. Full stop. The High Court had the benefit of engaging with both the first respondent and his daughters in the course of the proceedings. The substance, however, the order of the High Court did not specifically advert to what had transpired in the course of the interaction of the bench. This court had considered it appropriate to speak to the two individuals in respect of whom the habeas corpus petition was filed. Full stop. Both of them, full stop. The Geeta Kamraj and Lata Kamraj are presently of the age of 39 and 42.
Yeah.
Full stop. They had joined the ashram when they were 24 and 27 years old, respectively. Full stop. Paragraph 6 of the order of this court, which is being reproduced above, takes note of the fact that they had stated in the course of their interaction with this court that, bracket 1, they were residing at the ashram voluntarily and without any coercion, semicolon, bracket 2, they are free to travel outside the ashram, which they have done from time to time, semicolon. 3, as a matter of fact, one of them has even participated in a marathon run extending to about 10 kilometers in Hyderabad, semicolon, and bracket 4, their parents visit the ashram periodically to meet them. Full stop. The status report, which has been filed by the Superintendent of Police, specifically adverts to the two individuals in paragraph 23, 24, 25, and 26.
Yes.
Paras 23 to 27, which is reproduced below. Next. In view of the clear expression of both the individuals, a major,
29 also, para 29.
and 20?
29
and para
29,
29.
30. 29, 30.
29 and 30, right? 29 and 30.
Yes.
Both the individuals have attained the age of majority and in fact had done so when they first joined the ashram. Full stop. Once they have expressed their clear inclination to continue at the Isha Yoga Ashram in Coimbatore, and as a matter of fact have expressed, and don't say as a matter of fact, the purpose of the habeas corpus petition is duly fulfilled and no further directions were necessary by the High Court. Next. Having said this, in pursuance of it is necessary to record that in pursuance of the directions of the High Court, a status report has been prepared by the Superintendent of Police as noted above. The status report was directed to be filed before this court.
And based on what had been done till that date.
The status report is based on the inquiry which was conducted
till that date
by a team of officers of the Coimbatore Police till then. Good stop. All that needs to be clarified is that it was inappropriate for the High Court to expand scope.
Not required, and their action is equally illegal because it was not the High Court's
was,
order. Say you barged in without call.
It was inappropriate. Full stop. It would full stop. The jurisdiction of the court, the Article 226, when dealing with a habeas corpus petition, is well defined. Full stop. It would be unnecessary for this court to expand upon the ambit of these proceedings, which arise from the habeas corpus petition before the High Court of Judicature at Madras. Full stop. All that needs to be clarified, in view of the status report, is that this order would not come in the way of any further investigation which is being carried out by the police in accordance with law by the state authorities.
You not say that.
Obvious that this order, we'll say that.
No, we need to say this, Mr. Rose, because there are FIRs.
Because there are FIRs which are lodged.
Investigate in accordance.
And this is about some other person. We are not stopping here.
The problem is not below that I am scared of this FIR. Problem is that below all across the globe, these things are now.
What we will that's the problem. Two things may I just point out.
Stop them. We can't stop the speed.
You're right, your lordship cannot stop them. But the purpose of the FIR is something other than what is reflected.
What is stopping you from going to have to be clarified by your lordship.
Not saying stop.
May I just point out?
Also say no.
Lord, may I just say this?
Yes, what you will say that.
Can I just take a moment? Not this. Lord, please consider. There is not an ICC, there is not an internal committee. Now, if we issue notice tomorrow,
I am sorry.
Just a minute, Mr. Roki. Mr. Roki, please. Mr. Roki, please. You don't have an extra license.
We clarify that the only aspect of the matter which has been dealt with appropriately in these proceedings pertains to pertains to the habeas corpus petition, this order will close the ambit of that.
Why not the other aspect will have to be clarified, because I'll tell your lordship why.
Therefore,
Mr. Lord may have to clarify that. I'll tell your lordship why.
Prohibitory order.
Can I just why?
1 second.
Is there something more in
so much?
No, not this.
Mr. Rohati, Mr. Solicitor, just wait for a minute, Mr. Luthra. We have said that the ambit of this order is confined to the habeas corpus petition. So that was what arose before the High Court. And that aspect of the matter will remain closed.
My lord, may I now just point out what the issue is? May I just point out? Lord, as a lord, We went there as a consequence.
You know what, Mr. Luthra, just give me one moment. There is a concern. One thing, once we say that the ambit of the proceedings before the High Court was the writ of habeas corpus, and the ambit of our order is confined to the writ of habeas corpus, one thing which we have made clear is that we have not commented, nor should the High Court have commented on anything beyond the writ.
So my lord, we say that.
All right, that's we have said, that I have clarified. There was so much of heat which was being generated across the bar that perhaps you missed that when you were dictating.
Not on
Now,
time, lord.
No, 1 second. Neither you nor Mr. Rohatgi normally generate heat because it's all, now second, what we have therefore said is this, that therefore this aspect is closed by our order. Now, Mr. Luthra, what happens is, the moment we tend to elaborate upon anything wider, it seems to be, in today's times, these are really handles which are used by third parties to malign.
Well, that clickbait, that the Supreme Court directed inquiry, investigation.
Already on the news.
Yes.
I think not.
The moment, Mr. Luthra, the moment we say that we are closing only the habeas corpus aspect of the case, you know what that means?
Can I just, I think I do not. May I just take a moment now and clarify two things? Lord?
Yes.
Lord, your lordship will understand the state has shown great sensitivity. That is the reason I chose not to read out the passages of the affidavit.
I don't think great sensitivity, undoubtedly.
No, Lord, now I need something else. No, that's the state. Lord, who am I, Lord? I'm just representing the state.
No, but you argued the matter with a great deal of...
Yes, Lord.
Great deal
Yes, Mr.
Lord, I'll tell your lordship where the concern is. When we, Lord, to put it simply, Lord, para 18 and 19, Lord, there are certain regulatory issues. So it should, my concern is this, Lord. Your lordship may close the matter because what happened was we went there as a consequence of the High Court order. It should not be that those proceedings which, Lord, for example, if there is a regulatory breach in taking a license for an X-ray machine, for that, Lord, we have to act. We can't be, but that to that extent.
Just 1 second.
To that extent, Lord, it should.
We quite see what you are arguing.
Yes.
Now you have adverted, for instance,
yes, Lord.
to the fact that there's some X-ray machine for which the license
not regulated, but you need a license.
Now,
or the ICC is not there. The Internal Complaints Committee under POSH is not there.
All this came to light when you sent that posse of 150. Obviously, the state is in possession of details pertaining to the date up to which a license is valid. No, even apart from this, because you have possession of the license details.
No, Lord. I need to know you have an X-ray machine. May I just tell your lordship?
No, but who has given the original license?
May I just say?
You have given the original license.
May I just explain to your lordship what happened?
No, if they, suppose they don't have, now you've given the copy of the report.
Yes.
They require an X-ray, they require a license for an X-ray machine. They will apply for that license for the X-ray.
Something else.
Wrong. The statement is wrong.
My lord,
they have also talked about
may
a
I just say
crematorium.
this? Lord, may I just
permission from the state authority to build a crematorium.
Lord, may I just say, Lord, on the crematorium, I'm not even, Lord, crematorium is not subject matter.
I'm giving you an example.
That's in the High Court.
Many people
I'm sorry, Lord, this is besides the point. We're on something. Lord, please, I'm not on that. I'm not even on that, Lord. No, I just need Lord clarity because there is a concern we have. That concern is to be Sir, Lord, I'm sorry. It's very unfair.
Mr. Rohatgi, 1 second.
Para 18, PC. 18, your lordship, you should not argue on that.
1 second. This does not, Mr. Luthra, this does not have to be adversarial.
Yes.
For instance, they have referred in a part of the report which you have seen that, when you have women and when you have minor children, you have to have an internal complaints committee.
Yes.
Now, these are
just a minute,
one second, I say. Just 1 second. Let's do it in a sense of dispassionate application of mind.
Yes.
The idea here is not to malign an organization. Equally, there are some secular compliances which are required. For instance, you have to have an internal complaints committee. Now, this is something which Mr. Rohatgi, perhaps you have to impress upon your clients that whatever secular compliances are required.
This report is filed yesterday. I have our internal complaint.
Yes.
I have a regulatory.
My lord, it's not them, Lord.
Again,
it is not. Lord, it is.
So therefore,
make a statement like this. It's not there.
1 second. But is it bad that the committee has been formed? Is it bad that the committee has been formed? All right. Now,
matter is seized before this court. They have formed this committee since 2013.
So all the better. So therefore, all the better is the idea now to hoist them by their petard and now whip them because they didn't have a committee earlier. They have a committee in place, right? They have formed a committee now.
My Lord, Mr. Thakur's presence, my Lord, is something telling. He represents OBC Mahasabha in Madhya Pradesh.
So Mahasabha.
My Lord, this is what is the position, Manoj.
This is the problem.
The complete nobody.
Look, 1 second.
I'm only saying, just clarify that aspect.
I don't think Mr. Luthra, 1 second. Mr. Luthra has not argued that matter. He's not pitched the matter at that level.
No, he has been very circumspect.
There's a great deal of responsibility. Thakur, I'll tell you one thing. Your intervention is actually casting very grave doubt in the cause which is being pursued.
Exactly.
All right? It's very obvious what is happening here.
Truth always has a strange way of coming out.
Like these proceedings cannot be just to malign people and malign institutions. We are not giving them a certificate in the sense that if there are breaches, they have to rectify those breaches. We have clarified that the purpose of this petition arose from habeas corpus proceedings. The habeas corpus is closed. Mr. If there's any other compliance required, Mr. Luthra, please ask the state to engage with the organization. They will comply with.
But we've already. May I point the point is.
We can even record Mr. Rodley's statement that if any other regulatory compliances are required with provisions of law, the organization is more than willing to comply with those.
If not notices, they have to just get back. Lord, may I just say this, Lord? We acted, Lord. We issued notices. If they've complied, they'll have to take steps. If they've not complied, they'll.
Then, Mr. Rodley, you do this. If they've issued notices and you say have an internal complaints committee, please inform them that they do it.
Any issue of compliance
let them.
Will be dealt with.
Let Mr. Rogi's statement come.
If not dealt with.
Let Mr. Rogi's statement come, Lord.
May I please, my Lord?
Let Mr. Rogi's statement come. I think that's a fair way of putting it.
May I please, my Lord? I may be permitted to make my submissions, my Lord.
So these proceedings will not, the closure of these proceedings, it is clarified, will not affect any other regulatory compliances which are required to be by the Isha Yoga Foundation. As a matter of fact, Mr. Mukul Rodgi, learned senior counsel, you are appearing for the foundation.
Yes.
And Mr. Giri also, together with Mr. Giri, state that any such requirements would be duly complied with by the organization to ensure in accordance with law.
May I please, my Lord? Please be permitted to make some submissions.
Sure.
My Lord, the original background for the original background for filing, because I am the counsel on record before the High Court.
Right.
My Lord, your Lordship may kindly see page 114.
Just argue it. Now before the Supreme Court, you don't show pages here. Just come along. Formulate it.
There is a phone call from the daughter to the father on 15/6. Police until now have never even sought the call log or the call details or not the audio where the child says the daughter, I am on the fast.
Mr. Counsel, we have interacted with your daughter.
No, my Lord, that audio, I have transcribed.
Anyway, the police have verified. The police spoke to your client.
No, they have not.
Sorry, the police, you're appearing for the father. The police spoke to the two women. You have to accept the fact that they are 39 and 42 years old. Whatever your feelings towards your daughters, which you legitimately are entitled to have, when you have grown up children who have become majors, you can't claim to control their lives. We spoke to them. The police have spoken to them. We have therefore recorded the statement in the report submitted by the police from paragraphs 23 to 29. That's the end of the habeas corpus matter. That's all.
My Lord,
and you are really, as my learned brother says, you are justifying why your client filed the habeas corpus petition.
With that it ends. But the problem
we are not commenting on him adversely at all. Why should we comment on your client adversely?
Yes,
we are not
for
doing
a
that.
moment, my Lord, the status report, your Lord.
Why would we comment on him? We are also parents, right? We understand.
Yes, for age the children, maybe, my Lord, his father will have concerns.
Of
Parents
course
will have.
right.
My Lord, your Lordship may kindly see page 54 of the
But you are absolutely right. We are not saying that his concerns were not legitimate.
Make a few larger issue, my Lord, than your Lordship may discuss.
Don't raise anything apart from your concern as a father with respect
Yes,
to your.
certainly my concern as a father. Your Lordship may kindly see the page 54, my Lord, the status.
Tell us what it is.
My Lord, the daughter's statement given to the police, my Lord.
Yes.
Due to this, since 2016, we did not want to meet them and have not them very few times from till then, now 2024. So effectively what happens, my lord, in 2016, they file a habeas corpus that is dismissed, but for liberty is granted to the parents to meet the children in the campus once in a month. But thereafter, what happens?
Not
my lord?
children, they are adults, lady.
Okay, no problem.
And
All right. Sure.
Then what happens, my lord? They make attempts to see the children. Every time some scene is created. Subsequently, what happens? A injunction suit is filed by the doctor saying that my father should not disturb us. We filed an Order 7 Rule 11, my lord, application, and that was dismissed. Subsequently, my lord, we moved the RDO saying that under Senior Citizens Act, you may be a monk, but you have a duty to take care.
Let me tell you one thing.
Until 24.
Sir, Mr. Counsel, relationships between grown-up children who have attained the age of majority and parents, interpersonal relationships, these are never to be governed by suits for injunction and Order 7 Rule 11 applications.
Certainly.
This, if you have to truly, associate with your children, you have to get their confidence and not by filing, petitions. Now you know what the writing on the wall is. You have to get their sense of confidence in the parents. And if you have to talk to them, they've been meeting from time.
Regarding that only, I need some relief.
These are not minors that we can say, like in a child custody case, they'll meet the father twice a week or thrice a week. That you can't do in the case of somebody who has attained the age of majority.
Yes, ma'am. What happens? She herself says that until 2024, may I please, until 2024, she is not seeing the parents. My lord, your lordship may now see.
However great your anguish may be, there's nothing that we can do about it because she's a major.
No, my lord, we cannot.
If she's held captive, then of course we have all the powers under the world. But once we come to the conclusion that she is not being held captive, we can't compel people to meet each other.
The reason why we filed the habeas corpus was that she made a call and say that I am unto fast unto death. That is the reason. The phone log, transcript, everything is there. Till now, the police have not received the call log or even the phone audio recordings. They have not received from us. Nothing done. And moreover, the POXO case. Your lordship, may I please, my lord, may I please, only one submission. My lord, as a father, my lord, and they are grown-up women, my lord, they may not be, it is their independence, my lord, we cannot disturb them. But as a father, we have a concern that to secure their interest, or as long as we had to be concerned. My lord, what we are asking is, after all, my lord, only now, in the status report, they know how many persons are actually inside the campus. Let it not be this campus, my lord. Throughout the country, any campus.
Are you a political leader or are you now espousing the cause of the father? Now we have a feeling that this is not really about
this is something more than that. Just fatherly love is just a facade.
Look, let the state do its duty.
Just a facade.
My lord, my only concern.
The state, sir.
My lord, only one.
Sir, 1 second. Let the state do its duty for all the residents and citizens of the state, the citizens of the country residing in the state. You do your duty as a father.
As a father, my lord, my lord, the mother has also come. I am asking myself, my lord, I am aged 70 years. My wife is aged 65 years. We see daily news reports of abuse everywhere. We are not able to sleep. Every night when we sleep, we have nightmares. How my daughters are. That, my lord, all our request is that let the jurisdiction police send a woman counsel. I'll make my submission, your lordship.
You go there and meet them. Right? You go there.
No, we need not even meet them, my lord. Then they are not.
We are not going to send, you see, we are not going to send the police in.
No, my lord, woman constable in plain clothes once in a week or once in 10 days to ascertain whether.
You go there and meet them. No difficulty. You go there and meet them. You can meet them at their convenience and at your convenience because it's obviously a meeting between people who are above the age of 18. There's no question of sending the police in.
No, my lord, we are not asking anything, my lord. Let there be a monitoring, my lord. Now only this state has gone inside.
Thank you.
Once in a week, my lord, or once in 10 days, my lord, let them examine.
My lord, may I make a request on behalf of one of the intervener in the matter?
So interveners have no role to play here.
Yes, my case, minor is involved, my lord. That is deliberated by Honorable Delhi High Court.
There are more the interveners, greater the
We have not suspicion. Any other case. If there's a case pending before the Delhi High Court, you pursue your proceedings in accordance with law. We are not saying anything about any other proceeding.
Lord, if the observation can be confined to
10 seconds, my lord.
Observations, sir, you're appearing for the intervener. Our observations are very guarded. They are confined to this particular case of habeas corpus, which was before us. If you have any other proceeding pending before the Delhi High Court, we have not commented on them. We have not even referred to your Delhi High Court proceedings.
by application to withdraw to file a fresh writ petition. We are seeking the.
Kindly dismiss this with cost. Kindly dismiss this with cost.
Why this cost? We want to implementation of the law.
Have you imposed costs, Thakur? Have you imposed costs? Why are you unnecessarily creating ghosts which we have not?
No, my lord, this Mahasabha is, my lord, they go everywhere. Whenever they find some.
See, if you had imposed costs, you could have said, why impose costs? We have not imposed costs.
Not my learned friends. Not today, it seems my friend, the solicitor, being detained unnecessarily.
One state of yoga leads to it happened to Jackie wife also. My daughter is taking advanced yoga. You have to save the life. It is known as the hypnotism. Under hypnotism, Israel is a strict law. It's not to practice the yoga. But here is yoga gurus are practicing the hypnotism to the people. They are advanced state, they are dying. Jackie wife is dying because of Magasamadhi or advanced yoga. My daughter is practicing advanced yoga. Save their lives. That's all.
In fact, my lord, President of India attending Mahashivratri 2019, Forest Department has given a clearance saying that we will not give any protection for, we will not guarantee that elephant will not attack. This is a poor elephant area, my lord. Even today, elephant.
Well, that's not the subject matter of this, my lord.
Even today, my lord, lone tusker is.
But tomorrow, somebody may come and say that the food is not palatable. My lord, these are not issues to me.
We have concern, therefore.
Not the subject matter of habeas corpus now. Yeah.
No, my lord, they have enlarged the scope of habeas corpus by making grounds that religious freedom is affected.
May I please, my lord, submit in this matter? Your lordship, my lord, pass the order, my lord.
In the contempt petition, issue notice.
Much obliged.
Personal presence dispensed with, returnable in after 3 weeks.
Much obliged, my lord.
This has to be tagged, right? This has to be tagged.
Yes.
Tag this. We'll tag this. Item 5, 6, 10, 12, 14,
12, 14.
12, 14, 31 to 33 and 35.
That's right, Manoj.
They'll all be governed by the TOLA. Kal ka jo order tha na, TOLA mein, same order here.
I think my lordship had also included 10. I don't think 10 is the same issue.
10 is not the same issue.
10 is connected to a different matter, but
all right. So 10 hi aayega. So 5, 6, 12, 14, 31 to 33 and 35.
What is the issue in 10?
Issue in 10, my lords, is so for the same SSE for a different assessment year. It's a transfer pricing issue, my lords.
So it was a delay of 586 days. So we dismiss it on the ground of.
My lords, in fact, my lords have passed an order in the case of Xerox very recently, where there was a shorter
So
delay.
10 we'll dismiss on the ground of delay. We'll just call it out in 2 minutes.
Yes.
So we'll dismiss it on the
If
ground.
I can just say one thing when it comes up.
All right, yes. 7. 7 deals in this month. Item 8. Concurrent findings here. And the award is attained finality. Nothing in this. Dismissed.
Unilateral award has been passed.
That's all right. But it's attained finality. You have to challenge the award. 9.
Mediation may be granted, my lordship, in this case. It is a matter of 3 lakhs, my lordship. Mediation may be granted in this matter.
Item 9.
Obliged.
Item 9. 7.
Yeah, my lord.
7, sir, you are seeking a writ to the respondents to implement some policy in respect of purchase of defense production and exports. This is a matter of policy. We can't maintain a writ under 32.
My lord, what has actually happened? This policy related to national security. It was declared in 2020. It has not yet been implemented.
That's all right. That's a matter. That's not a question. Can entertain under it. How is your fundamental right affected?
Sir, fundamental right affected is that if national security is compromised, I think for everybody
it is the government to handle national security. This is not for us here in a PIL like this. Challenging, seeking implementation of the defense production and exports promotion policy to reduce the dependence on imports and protect national security. This is not within our domain. Dismissed here.
My lord, can I say something, my lord? Can I have few seconds? Can I have few seconds to say something, my lord?
Yes.
My lord, this issue I had taken up with the PMO also. It has been informed by the Ministry of Defence to the PMO. I have an Annexure 9 attached, my Lord, on record, that the policy has been implemented.
So, but there are some matters which are not made for the court. You're not saying that, you can pursue the matter with any other ministry, etc. But whether a particular policy, to what extent it has been implemented, it's not something relating to, the labor welfare or something like that. These are matters purely in the policy domain of the union government, and they have to decide how to implement this particular policy.
My Lord, in a similar situation,
you can pursue your remedies with the government in this.
My Lord, in a similar situation, this Honorable Court had issued a direction. If I'm allowed to quote.
What is that in relation to?
In the similar relation, my Lord, Bombay Municipality versus Advanced Builders, AIR 1972.
That may have been relating to that would be relating to urban planning, some environmental norms. Yes, there we certainly intervene because there the fundamental rights under Article 21 are affected. Advanced Builders was that kind of a case. That's the reason. Thank you.
Not in the policy.
Item 11 now, no? 10 to...
Number 9, my Lord.
10.
Number 9.
We are dismissed 9, sir. No, not 9 again, you are there.
Yes, sir.
You are Madan Gopal Agarwal.
Yes, sir.
Okay. You want clearance of all pending cases across all courts, Supreme Court in 12 months, High Court 18 months, District Courts 30 months, Executive Revenue Courts 36 months, Village Courts 36 months.
Yes, my Lord.
Very desirable, but unachievable because, you have to have adequate infrastructure, judge strength.
My Lord.
And a variety of other... You can't file a petition like this and make us read this.
My Lord, 20 countries globally have implemented a system. I made a presentation to ministry.
You're right, but we are not the American Supreme Court. How many cases does the American Supreme Court deal with in a year? You know that. And how many? We probably all 17 benches deal with more cases in one day than the American Supreme Court will deal in the entire year. Every day I get a log of how many cases have been disposed of. We dispose of in one day more cases what, say, some of the Western courts dispose of in a whole year. Because we have created an access to justice model. Idea was to allow poor people to come to this court. But that has created delays. If we start restricting who can come to the court, what kind of case will be we'll also knock out all these areas in 1 year. But that's not our model because we are a different society.
That is neither my intention nor a proposal, my Lord. Not to restrict anybody, my Lord. As many has to come and should come.
We have disposed of over 100,000 cases in the last 2 years. That's those are the statistics. Anyway, thank you. 11. 10. Delay of 586 days.
My lords, but same SSC, same issue previous year, that matter is pending.
We'll keep the issue open, but we will say that we'll not condone the delay of 586 days.
Significant tax effect also.
On delay, but questions of law are kept open. 13. 11.
My lords, please, my lords, may I request that my appeals may be marked in this matter?
Yes.
Grateful, my lords.
11.
My Lord, in item 11, this is...
Let it be tagged. They are all... But I have one submission. If Lordship kindly says, Annexure P5,
what is
all the parties who are the petitioner in the writ petitioners have not been added as a pro forma respondent also. So that let them amend the cause title.
What is there, my Lord?
You can raise it at the time of the...
Yes, my Lord.
You can
Let them file that amended memo.
Let her take her petition. You can always argue it.
Registry has cleared this
anyway
under the practice.
Right. Yes, just tag it. Item 13 now.
My Lord, there's a delay of 44 days, my Lord.
Delay control.
I'm so obliged.
13.
13, my lords, this is Ganpati Dealcom. In terms of my lord's order of today, I think it will have to go back. My lords had in the last portion indicated that where it has been relied upon by the High Court, there is liberty to approach. I think that's what my lord had indicated.
Right, but we'll have to issue notice. We'll have to issue notice. The judgment in the judgment in Ganpati Dealcom has been recalled in the exercise of the review jurisdiction by this court by an order passed on today. To citation will issue notice, hence issue notice, returnable on, liberty to serve dusty in addition.
There's a delay here also. 202 days delay.
Where? Item?
In 13, my lords. delay of 202 days.
That's all right. That's all right. Because there we have already recalled the judgment and High Court has followed the same.
Followed it.
He'll issue notice on delay also.
Obliged.
Now, this is for OTT regulations. Because the different
keep on filing these kind of every 2 weeks you have filed a new SLPIL. But you know, for us to your reliefs are constitute an autonomous body board, namely the Central Board for Regulation and Monitoring of Online Video Contents, appoint an IAS officer at the secretary level, issue a writ, appointing an amicus curiae. I mean, these are, let governments do some work. I mean, you know,
there's one small submission. Last time when I moved a petition, and that is why I am filing it again, IT rules came.
The problem is now PILs, actually the kind of PILs we are getting, we have no time to deal with genuine PILs because we are only reading PILs of this nature. These are purely matters of policy. How to regulate the internet, how to regulate OTT platforms. This is not something we can do in the exercise of our jurisdiction under Article 32. This requires stakeholder consultation, multi-stakeholder dialogue. The government of the day has to weigh the pros and cons.
Just one small submission. It may be dismissed if this court feels like just one small submission.
Yes.
When I came here last time in 2022, thereafter IT rules came into existence. Now the difficulty now is both for creators and viewers. There is a setup where you have to seek permission and you publish a movie and people watch it. And on the other hand, there is this setup for OTT where contents come on their own. There is no regulation, nothing. So in 2023, when this honorable court disposed of the matters, they stated that if we have some difficulty, we can reapproach this honorable court. Now, why I came before this honorable court? Just last month, there were 2 movies which came into public. One was on OTT, one was on TV. One was on theater. The theater movies could not release till date, and the OTT one got released, and then ministry had to intervene, etc. So my only point is right to equality should be maintained now. That's it.
No, thank you.
Because I may be granted liberty to approach the ministry. Because I may be granted liberty to.
Dismissed. Item 16. Please put up by something, no?
Lordship, I'm appearing in item 16.
Yes.
Lordship, this petition is PIL filed before Delhi High Court, and it is also about the madrasa.
Let the Delhi High Court deal with it. Why should we transfer it here? Let us have the benefit of the judgment of the Delhi High Court.
My lord is already seized with the issues of madrasa education in Anjum Kadri, which is listed on 21st.
Whoever wants to intervene, let them intervene in that matter, but we will not keep on transferring matters from the High Courts over here. We have got one batch of matters, we'll hear that. If Mr. Upadhyay wants to intervene in that, we will hear him. No difficulty.
The requesting is this. There are a lot of judgments here, like case Syam Sundar versus State of Tamil Nadu. This is the judgment by Hon'Ble 3 judges, my lord. I read the 2 paras only. So it will set.
But you are supporting them.
No. My only
wants to transfer your petition.
My only concern is, my lord, if something goes here, my lord, against me, I am in High Court.
You intervene, therefore. You intervene in that matter. You can always file an intervention. We'll always hear you. No difficulty.
My lord, my matter is there. There is another SLP, my lord, here against the order of judgment of the Guwahati High Court. There are 2 other petitions also. So
that's all right. You can intervene in that. If you have anything to say, you can always intervene. But we don't want to start transferring matters from the High Courts over here.
Just Lordship, give me permission. Only read 2 paras. Only 2 paras. Just see the case Syam Sundar State of Tamil Nadu.
We are not going to transfer all these petitions. Let the High Courts deal with their petitions.
Lord, if something will go against me, my lord.
Nothing. Therefore, nothing will go when you are there watching the proceedings. You argue those proceedings. Thank you.
No, but madrasa is going.
Item 17 now. Item 17.
With your lordship's permission, I appear in item.
It has to be tagged. The UP teachers. 18.
Wait, please. In item 18, your lordship's grant is a passover. My lord, Mr. Venkatraman is appearing. He's on his legs in court 14.
Right. 18, no?
18.
Before a bench of which I'm not a member because I'm the patron-in-chief of the National Judicial Academy. Let it go before a bench of which one of us, Mera naam, is not a member.
As it please.
This is 11.
Next, coming up for the first time, Milord.
You are appearing?
I'm for the non-signatory, Milord. Your Lordships may issue notice because I need to file a reply.
Right. Issue notice. And Mr. Nakul Diwan appearing with so and so. Wait service for the
respondent number 2.
Second respondent.
Here on camera.
All right.
Final-
Available in 3 weeks, we'll say counter be filed in the meantime.
I'm deeply grateful. Because now, Milord, with your Lordship's latest judgment in Ajay Madhusudan, Milord, it's quite clear what the issue is. I'll address your notes as a non-signatory because these are UNCITRAL rules which are
all right.
here.
20.
Grateful. Obliged.
Yeah. Were your Lordships aggrieved by the failure of the Honorable NCLAT?
We are not going to entertain petitions like this when the matter is pending before the NCLAT.
There's only one difficulty, my lords.
Without pursue the NCLAT because it's now becoming a new fashion. The moment NCLAT adjourns the matter, you come here.
May I only bring two facts to your Lordship's
We don't want to do
that. We filed an early hearing application. Thereafter, even without hearing me on admission, without hearing me on interim relief, it's coming in the after.
It's on the 4th of October and now it's adjourned to 12th of November.
But at least on that date, if it can come along with the admissions, I'll be heard. The difficulty is it's coming in the after admission category.
But
I've pursued trial.
Decided over by a former judge of the Supreme Court. You have to move that judge. You have to move the precedent.
I moved the judge mentioned twice. I have filed an early hearing application.
All right. But then that's their jurisdiction to decide whether something is urgent.
One request. Can I only make one on that?
We'll leave it. Thank you.
Let me heard only on
not do anything like that. Let them be in charge of their proceedings. We can't control every tribunal.
The stay application may be considered on that date. The difficulty is
item 20, 21.
Can I withdraw a liberty to approach the Honorable NCA?
You can simplicity withdraw, no difficulty.
I'll withdraw.
Dismissal withdrawn. 21.
21. Talks are going on between PSUs, so maybe called after.
All right. Since negotiations are going on between the public sector units on the joint request, list after 4 weeks. List on Tello after 4 weeks. 22 also, right?
Your Lordship, 22 is not coming the third time. Your
Lordship, in item 22, I am led by learned ASC, Mr. N. Venkataraman. Your Lordship, I am seeking pass over.
Lordships had not gone through the judgment, but
Yeah.
should call.
Venkataraman wants to pass over.
That's all right. I am.
Oblige, Your Lordship.
23.
Please, my lords. My lords, this is the arbitration petition in which, my lords, on the last occasion, I had informed my lords that respondent number 1.
The liquidator in Malaysia.
Yes, my lords. So they.
Your Lordship, I appear for the petitioner in the matter. Our counsel is unable to connect right now. So may I request for passover?
My lords, I have no instructions because earlier I was appearing for respondent number 1, which has been wound up. Now, liquidator was completed, but they have not been served.
Ma'am, you served the liquidator, no?
The last office report says so that we have served and they have got the copy. Last time they have appeared in the matter.
My lords, it states that the High Commission of India, which is in Malaysia, they received the notice as unclaimed, my lords. The respondent number 2, which is CJI, they also received a notice back as unclaimed, and that has been allowed as deemed service, but not for the.
But on last occasion, they never speak about it.
There is a notification of the liquidator in which the emails are written. So, my lords, if the petitioner can email them and file an.
Why don't you send an email to the liquidator, ma'am?
I will try to, but I want the exact email ID. I don't get
the email ID. You have to figure it out yourself.
My lords, it's in the amendment application which they had produced. My lords.
Okay, I will try to serve them. I'll serve them. But
appearing on behalf of the petitioner to serve the liquidator who has been appointed in Malaysia to the electron through email. List after 4 weeks.
Grateful.
24.
Email ID.
Item 24, my lord, I am for the petitioner, my lord. There is a designation, my lord, of Mr. M.C. Dhingra, my lord, who is appearing for the respondent. So they have to file wakalatnama, my lord, in that matter. So, my lord, may have it after 2 weeks or so, my lord. I am for the petitioner, my lord.
My lord, I'm for the respondent in item 24.
Yes.
The former counsel was designated as a senior
This
recently.
is what I said.
Certainly. So I am seeking 6 weeks time to file my counter.
Appearing on behalf of the respondent has since been designated as senior counsel. It's upon the request made before the court. We stand over the proceedings we adjourn the proceedings by a period of 4 weeks, 6 weeks.
I'm so grateful.
To enable the respondent to enter appearance to alternate counsel and to file its counter affidavit.
Grateful lordship.
For item 25, I appear for the petitioner.
Yes.
The subject matter of this dispute, my claim against DMRC is actually dependent upon another civil appeal which is pending disposal before this honorable court. So I am only requesting that let this matter be listed after 8 weeks. The matter is already listed at 113 in every weekly list. It is likely to be listed because in case I succeed there in that civil appeal, then this dispute will not survive. Then I will have no claim.
This is section 11 petition. Their main grievance is that we have not served them with the broad-based panel. So we are serving them the broad-based panel. Right now, I'll give it to him. He can choose.
I have been served with a broad-based panel. In case I do not succeed in that civil appeal, I will choose from that broad-based panel and we'll go ahead with the arbitration. So I'm only requesting that it may be listed after 8 weeks. If I succeed there, then I don't need to choose. Because then
in which case you will not pursue the...
Because my claim will be over. Because I'll have then no claim against him.
Appearing on behalf of the petitioner, the learned counsel appearing on behalf of the petitioner has invoked the proceedings, has invoked the provision of section 11(6) of the Arbitration and Conciliation Act 1996. Learned counsel appearing on behalf of the respondent states that the respondent is willing to provide a broad-based panel to the petitioner for the purpose of the appointment of the arbitrator. Responding to this submission, learned counsel for the petitioner states that the present proceedings are contingent on the outcome of civil appeal number
1218 of 2012.
1218 of 2012, filed by the petitioner. And full stop. It has been submitted that if the petitioner succeeds in the pending civil appeal, nothing further would survive in these proceedings and the appointment of the arbitrator. Since the appeal is stated to be on board before a coordinate bench, list in the month of, we'll keep it in the third week of January then.
Please, I'm obliged.
26.
May it please, my lords.
Who is appearing here?
My lords, I appear in all three matters for the respondents. My friend appears for the...
For the respondent?
Yes, my lords. 26.1 and 2, my lords.
It's for the appointment of an arbitrator? Yes.
May I just say this? This is a 38-year-old relationship between these two entities. It has withstood 2 monarchs and 3 constitutions. All I am saying is, my lords, please, per clause 15.15a, please allow us to have a conversation, try a friendly settlement, and if it doesn't work, we'll come back to
What we will do is, Dr. Guruswamy, what we do in such cases is we appoint an arbitrator. We say that parties will first negotiate with each other.
I'm sure
the negotiation fructifies into a settlement.
I'm very grateful.
We had appointed an arbitrator. It's a 3-member.
You had appointed you can appoint one arbitrator.
Yes, my lords.
How much is the claim?
It's many areas of dispute. This is a distributorship of the products that my friend makes, motorcycles, etc.
It's more sensitive information because it's a distributorship agreement. The value of the claim may not be fixed.
So we'll appoint sole arbitrator by consent.
Yes.
Right?
Yes.
Should we appoint Justice Badr Durraiz Ahmed as the sole arbitrator?
Yes. Right? Grateful. So grateful. And my lords may please indicate that let us try negotiations and mediation.
At the end, itna hi likh lijiye. Learned counsel, responding to the request of Ms. Dr. Menaka Guruswamy, learned senior counsel for the respondent, it has been agreed that the party shall, in the meantime, attempt a good faith negotiation so as to explore the possibility of a settlement of the underlying dispute. Stop. Parties are granted time until, is it 31 December?
Yes.
That may be a little long,
All right,
4 weeks, because we are
until today we are
15th of November.
Until 30th November, 30 November.
In Nepal also, my lord.
30 November 2024 for attempting an amicable settlement. In the event that no settlement is arrived at by 30 November 2024, the learned arbitrator would be at liberty to proceed
Grateful.
further in the arbitration.
I'm so grateful, my lords. I'm grateful.
Well, we can just take a statement from my learned friend. There are litigations filed against us, so they won't take any further steps in those litigations till.
My lords,
litigation.
nothing moves in Diwali, my lords.
I'm saying, just a statement from her.
Nepal, my lords.
Just tell them not to.
I'll do that, my lords. I'll do that. I'm so grateful, my lords.
Obliged.
Who's appearing for the other side? We appoint an arbitrator.
I have instructions that we'll nominate our arbitrator within a week because the clause provides for 3.
Why don't you both agree to 1 hour? How much is the claim?
Under the notice, your lordship, approximately there have.
You have nominated Justice Mukta Gupta. Let them nominate their arbitrator within 1 week. The petitioners have nominated Justice Mukta Gupta, former judge of the Delhi High Court, of the High Court of Delhi, as an arbitrator. The Learned Counsel, appearing on behalf of the respondent, states that the respondent would nominate an arbitrator on its behalf, nominate an arbitrator on or before 25th October 2024. To stop. The 2 arbitrators would be at liberty thereafter to complete the composition of the arbitral tribunal by nominating the 3rd arbitrator. Hello. The petition is disposed of.
Hello. Lord, I appear in a matter 28 for the petitioners. We've served by email. We are in the process of serving by way of the official mode of the Honorable Supreme Court.
So should we just stand this over by maybe 4 weeks so that service is completed?
Well, that would be great. But my lords, the only issue is, my lords, we had also filed a Section 9 petition. They've been not appearing. There's been no response. That has also been ex parte now as per the Honorable District Court. So we worry that even a delay would not be appearing as such. And then I leave it to my lords to whatever the correct mode to do.
Where is it based in actually?
My lords, they're based in USA, but this is no more functional. So the only communication which we have since the last couple of years with them is through the email of one of the directors. And even after we'd invoked the arbitration, they called us for a settlement meeting in Thailand where we appeared, we negotiated, but nothing has been there. And after that, they've just abruptly breached and gone and had a contract with some third party in total violation of a contract. It's only the arbitral tribunal that has the power under the contract to determine if there's a breach or not. And even the termination can be determined by the tribunal itself.
Since service through the official channel is incomplete, list on, keep it in January sometime.
Grateful.
Because had asked us to examine the report and suggest a way forward. So I've examined that. Because they are saying that in terms of assistive devices, there's no clear guidelines. So there was something that even the committee was struggling with. So I am suggesting that on aspect of assistive devices and reasonable accommodation, which is a larger principle, an assistive device is only a part of it, the Lordships may consider appointing Dr. Satyendra Singh, who has substantial experience, along with the existing panel, and so that they can examine if this person can be reasonably accommodated, for the reason that I filed the affidavit also. He's online as well.
Dr. Satyendra Singh actually?
Malaj?
Who is Dr. Satyendra?
He runs Infinite Abilities. He's a doctor who himself has a disability, and he runs a whole aspect. They can also examine Malaj. He is very reputed in the area, and they can get back.
Yes, I would want Malaj to just go through the report once. These are 5 doctors. Earlier, the petitioners were apprehensive that there'll be no doctor with special abilities there on the panel. There is one, though it's not mentioned. They don't want it to be mentioned specifically, but I can tell Malaj, Dr. number 3. Dr. Junaid Alam is one who's...
Where do we get the report? In the additional?
Plus page 19 of the ROP, it should be. ROP file page 19, I understand.
It's the last document.
ROP 90?
Page 9.
One line.
So, Dr. Junaid Alam, who is at number 3, is with special abilities. and he was there on the panel. So assessment-wise, Manoj, I don't think so they should have any issues. What they are saying is, when you say that with the aid of assistive devices, if the disability can be brought down from 80%, then he can pursue the course. Now, even with the aid of assistive devices, which are two in this case, which he has used, crutches and the scooty which he had got, with that also the disability is crossing 80%, which is around 88%. I've been told it's
Well,
not
they
mentioned
say,
here.
however, they are, I'm sorry
I'll
to,
just
Or there are no clear
yeah, that's the point I wanted to emphasize. So the committee was also, it's recognized that there was a challenge in making assessment. And that's why I'm making that suggestion.
They're not saying there was a challenge, but they're saying
So
there
they
are.
say there are no clear guidelines available to assess the disability with assistive devices as per Government of India Gazette guideline.
Yes.
And Malaj, Dr. Satyendra Singh Malaj runs its infinite abilities, and Court 3 has recently passed a judgment, Malaj, 2 days back. They recognize in para 51 of that. So I'll place that as well. His contribution to the area. So Malaj, para 51 of Court 3's judgment, just place that. Fine.
I saw that.
Yes. So Malaj, para 51 says, before we part, we'll do well to recollect that acclaimed so-and-so, Arunima, who is Mount Everest, and Dr. Satyendra Singh, the founder of Infinite Ability, are some of the shining daughters and sons.
Malaj, we have no dearth of doctors in AIBE.
Well, I am not imputing anything, Malaj, but it's just a question of approach. Malaj, I'm not imputing anything on the committee, but addition cannot, Malaj, certainly, because we are, Malaj, in a situation, Malaj, let me put it like this.
So should we ask Dr. Satyendra Singh to look at him and then give us a report? Or what?
Malaj, that will be ideal, but if
doctors, 5 of them, Malaj,
Malaj, that will be ideal. In my respectful submission, that will be ideal.
like this, Malaj,
And he has, Malaj, doctors with disability. I'm sorry.
Malaj, I have a submission to make here.
Well standard last year.
I'll just check.
This year.
Last year, Malaj, yes.
Last year.
Correct. I'll get the name. Just give me this. I'll just give that, Malaj. Plus, he has PWD 80 for the rank.
By report, the person to the previous order of this court dated, previous person to the previous order dated. 27 September 2000.
3rd October.
3rd October. 3 October 2024. A 5-member board at the All India Institute of Medical Sciences has submitted the following, submitted a report on the evaluating the disability of the petitioner. That last para. Just the report insofar as material is reproduced below. Page 19 last para, the candidate was reassessed up to MBBS course. Prima facie, it appears, prima facie, the above extract indicates that the committee felt that that the committee noted that there are no clear guidelines available to assess the disability, with assistive devices in terms of the guidelines issued by the Government of India. So having said this, we do not find any independent evaluation by the committee on the extent of the functional disability, and we do not find that there is any independent evaluation on bracket 1, the extent of the functional disability of the petitioner, semicolon, and bracket 2, the extent to which the use of assistive devices would have the potential to bring the extent of the functional disability to within permissible limits in terms of the government notification. Good stop. We note that in a recent judgment of this court, in both the
Just the fact slightly different judgment.
in a recent judgment of this court, in Omkar Ramchandra Gond versus the Union of India and others,
Para 51,
which was rendered by three judges on in a bench of three judges in civil appeal number 10611 of 2024. The
Para 51, your lordships will have at the bottom.
51.
At the bottom of that, the name is there. Before we part, we will do well to recollect a claim so and so, and Dr. Satyendra Singh, the founder.
There is a reference to Dr. Satyendra Singh, the founder of the founder of an organization by the name of Infinite Ability. Good stuff. We have the considered view that a domain expert from the area would better serve, would subserve the ends of justice of a young student who seeks to pursue a career in medicine. Issued by this court in Omkar Ramchandra Gond in that regard are of great relevance and are reproduced below insofar as is material to the present controversy. Or copy down from paragraph 53, 1 and 2. Next. Is there any other person from, we'll ask Satyendra Singh. We therefore request in the above backdrop, we request Dr. Satyendra Singh, Satyendra Singh of
Infinite Ability
to take up the assignment which is being entrusted to him by the present order, and to specifically assist the court on whether, notwithstanding the quantified disability, the petitioner can pursue the MBBS degree course, particularly. In arriving at its evaluation, Dr. Satyendra Singh is requested to examine the petitioner and to have due regard to such assistive devices and their potential to assist the petitioner to fulfill the requirements of the degree course in medicine. The report of Dr. Satyendra Singh may be submitted to this court we'll ask by Monday.
Yes, ma'am.
On so and so in seal cover. They don't say in seal cover. Maybe submitted to this court by Monday.
I'm so grateful.
I'm grateful.
Oh, maybe a happy man. Help him.
This is not adversarial. I'm agreeing.
No, the ASDS,
you can bring the report if you want in a cover, and you can just tell Dr. Satyendra Singh that it can be given in a seal cover to you. Can you place
I'll place it before the court. I'm so grateful to the court.
We're giving appearance online.
Yes, sir.
Physically.
Item 30.
This was the respondent on caveat.
60. Respondent has not been granted. Interim stay has not been granted.
We have to now refund something like 78 crores in relation to.
All right. It's subject to the result of the proceedings.
No, my lord, it's a public utility concern.
That's all right. We'll not.
It has to pass, my lord, through to the consumers. No.
That's all right.
My lord, if you're not,
you'll get your refund if they fail ultimately.
Fair enough, my lord. Then
if you succeed.
My lord, but there's only one aspect of it, my lord. The direction is to refund this with interest. Let the interest part of it be state. We'll
That's what.
Otherwise it comes to more than 30 crores out of 77 crores now.
That's all right. I mean, they've set up they're after all.
No, there are concerns. It's going on even now. It's generators, we are purchasing it from the generators.
They got it with interest too, Lordship. So I think Aptel is seized of the matter.
Get it with the interest. It was a recovery.
Will not get the
I'm so brief.
No, my lord, put your lordships and kindly see.
These are all commercial matters. And this will abide by the final result of the Aptel proceedings.
That's correct.
But they will also have the benefit of they've invested money.
No, my lord, I only thought, could your lordships only have a look at page 162? That's the order.
Nothing sounds like a great moment for us.
No, just one moment. Let's see. No, Lord, we are refunding it, we'll refund it.
Yes.
If your lordship speak, because there is no stay. Ultimately subject to the final disposal of the appeal. The only aspect on which, my lord, I thought I could address your lordships is that this, my lord, it's not a per se recovery. It was paid at the rate of 5.08. It was brought down to 4.67 by the first order passed by the commission. And therefore, my lord, the remaining, my lord, it was recovered from them. The differential was recovered from the generators. Out of the amount which has been paid to them, not for the regular supply. Now, my lord, there is a direction to pay it, my lord, in 23. Now, my lord, it cannot carry the liability to pay interest from 2016 onwards.
That's all right. Thank you, Mr. Giri. Item 36.
Could your lordship only say that we are entitled to move, my lord, the tribunal, my lord, if necessary for extension of the time for making the payment.
That right is there.
That can always move to one. What is the period prescribed?
Lordship, actually the original notification is of 15 for 8.5 months and the government notification under section 11.
For the payment.
No period is prescribed. Period is not prescribed
No
under
period
the
is
order.
prescribed.
No.
So now,
Not the.
okay, now, I mean, since there's no period, why should there be an extension?
Very good.
Item 36. 36, we have already dismissed one matter.
Yes, my lord.
So we'll dismiss.
Yes, my lord. One more submission, which is not unreasonable. My lord, the tribunal is not burdened, or my lord, only these cases are pending before my lord appellate tribunal. A time frame may be fixed.
Can move the tribunal. Item 37.
37.
Identical matters. The same order is coming before Court 15. It came today. Tell Lordship what happened.
What happened in Court 3?
Court 14.
Court 14.
What
happened?
No, they just posted on 10th of December for arguments. Tell Lordship what happened. My Lord, we are all set up solar power plants on the basis of the government order saying that you can get this duty free. Permissions were granted by the commissioner. By a letter dated 9/7/2022, they said all permissions are wrongly granted, withdraw it. We question saying that, look, once the permission is granted, you can't by a subsequent letter withdraw the permission granted much earlier. That permission was quashed by the Delhi High Court, and other issues also were taken on the scope of section 65. Now, my lord, what happens is the order of the court is 6/5/2024.
Yes.
Of the Delhi High Court, the first order, which is at page 42.
By which the 9/7/22 instruction was quashed.
Now, if a lordship comes to page 210, 209.
What happened?
He relies on that 9/7/22 order on 24th June and says, I'm withdrawing permission. So what I'm saying is once that particular letter which you're relying upon has been quashed by the Delhi High Court, you can't rely on that letter to take away my permission. Please come to page 209.
So they are relying on that very letter of 9th of July 20.
Which was quashed 2 months ago.
Now this, the High Court has dismissed your petition on the ground.
Go back to Andhra. Not only one stay, because I've taken all the loans I've supplied to Andhra Electricity.
Notice on stay, Karo.
Can you stay because because the letter is gone, my lord.
We'll do a notice on stay and make it returnable next.
We should not be used. My friend says, can we use that, my lord? The permission granted can continue at least, my lord.
Anyway, we'll issue notice on stay. Come here. Within a week. Yes. We'll come within a week. We'll take it up.
Because that same.
Or immediately after Diwali, we'll take it up.
No, because what the point is, all the solar modules are on site.
Yes, then in fact 10 days.
No, the modules are on site. I can start generating electricity. It helps nobody.
Anyway, 10 days will not make a difference, yes.
38.
Any lordship giving a date?
Monday after Diwali.
Monday after Diwali.
We'll take Dusty.
Yes, Dusty, yes. What is this? Matters pending before the Bombay High Court and you come here.
The only concern was PDF 270, my lords. It's a 1 year tender.
That's
Tenderable by.
You pursue the proceeding before the High Court. You know, High Court is other important matters also. You dismiss, yes.
Maybe then we
39.
say that on 12th November it may be taken up and not.
Can that you pursue before the High Court, yes. Item 39.
Just kindly give us that liberty, my lords. Grateful.
Yes.
Sorry, we trouble your lordships with orders which are merely adjournment orders in NCLAT. This happens, this problem is also there repeatedly. Why it's happening is, suppose the company, there is an CIRP against me in June. In 270 days, they have to complete the process. If the NCLA...
On 19 July 24, we directed you to application for the NCLA.
After that, 8 hearings have taken place. The matter is part heard and now it's now put to 27 November. My learned friend is here also on caveat. So we are stuck, Miller. That's why we trouble your options. I feel embarrassed.
My lords, may I point out? My lords, on the next date itself, the matter was heard and it's a part matter. And it's now listed on 29th of November.
29th November, Millers.
We can't do that.
Yes, well, 6th hearing, but what happens, my learned colleague is also there, Priyanka is also appearing there. It's last item on the list, doesn't reach. So we said, let's hear the stay application. We said, hear the appeal itself, very well, no difficulty. So now for 6-8 hearings, Millers, and half of the time is gone, Millers. So we trouble your lordships. I know I'm very embarrassed, but what to do when Ms. Priyanka says we're not getting heard? What do we do, Millers?
Can jointly move the bench for an hearing of the stay application.
Right,
if it is not possible to dispose of the appeal and take it up within a period of say 3 weeks today we are now on the 15th, 17th of October. Let them hear it by.
We will file our application on Monday. Let the NCLAT take a call on the stay application within 10 days. That's why I'm requesting.
I have no objection even if on the next date the matter is heard. Finally, I have no objection on that.
That is in November, Millers. 4 meetings of COC has already taken place. Then Form G will be issued, bids will be called. Millers, some kind of solace to be.
Because it's only 29th of November. That's why I was submitting that if it is heard finally also, we are good with it.
Between now and 29 November, what will happen?
Plus, the COC Form G will be issued. Once Form G is issued, bids are called. Bids are called, markets, people will bid for it. Now, suppose my appeal is allowed.
They are not, I am appearing for the operation creditor, my lords.
He's the person who initiated the.
So you can say that up to the next date, you will not take any
COC has to take a call. They can't decide. They can't decide. COC has to take a call, Millers. That's again a problem. So I was suggesting, Millers, well, I'll move the stay application on Monday. Millers, NCLAT may process it and hear it within 10 days, Millers, one way or the other, or the stay application, Millers.
On 19 July 2024, while disposing of the appeal, this court had permitted and on that date, the matter was coming up on the 7th.
7th August, yes.
On 19 July 2024, this court dismissed the appeal filed by the appellant since the proceedings were due to come up before the NCLAT on 7 August 2024. Full stop. Liberty was granted to the appellant to move the application for stay. Full stop. The grievance is that thereafter, the proceedings have been adjourned on 8.
Yes, the last 14th October was the 8th adjournment.
On 8 occasions, the last of which was on 14 October 2024, and the proceedings have now been adjourned to
29th November.
29 November 2024. Full stop. While we are not entering upon the merits, we are of the view that the NCLAT must hear the application for stay within a time-bound period. Full stop. We permit the appellant to move an application for stay no later
by Monday will be today itself.
Yes, as stated by on behalf of the appellant by Shri Gaurav Agarwal, Senior Counsel. Full stop. The application for stay is moved. NCLAT shall dispose of the application for stay no later than within a period of 2 weeks of the date on which a certified copy of this is placed on the record.
Grateful to your lordship. So obliged to your lordship.
The appeal is disposed.
Grateful to your lordship.
40.
Because I am a registered trademark. So I am a registered trademark user. I am not only a registered trademark, but also a user of that trademark. And as far as there is concerned, they moved an application under class 41. That class 41 application was objected to not granted.
Released or no? That's then it's like.
Now, what has happened? You just have a look at it.
Jigra.
Now look. Please kindly just see. See para 9 minutes. Can you sustain para 9 minutes?
Has done well at the box office.
Thanks to him, it might.
Dr. Singhvi can have appeared. It must be doing very well.
No, but it's thanks to him.
Not doing very well.
Asha, so you have three.
Doing my name.
But it's thanks to him, he might have got some unintended publicity. He doesn't realize that he might be helping with unintended publicity.
Doing my name.
SLP.
That is what has happened.
Withdraw his SLP.
Kindly see para 9 of the High Court order.
Not a case for us.
Just have a look.
Film has been released now. This is the thing. How can we now set the clock back?
What is the problem is that this para 9, let's just have a look at para 9. Can we sustain para 9 of the High Court order minutes? Now, one day before the film is to be released, on 10th minute, this is the order which is passed by the High Court minutes. Otherwise, 8th minutes, the court had granted me injunction, which was rightly so following the Lordship's orders. And since I am a registered trademark holder minutes, there was no occasion for this is a clear case of infringement. Just look at para 9 minutes, page 3. At the threshold, taking into consideration the 3 parameters of prima facie case, irreparable loss and balance of convenience. Court is prima facie convinced that the name of the movie in question would not infringe.
Actually, where is that actually?
Yes, minutes.
1 second.
Page 3, para 9 minutes.
Yes.
At the threshold, taking into consideration the 3 parameters of prima facie case, irreparable loss and convenience, this court prima facie convinced that the name of the movie in question would not trademark rights of the goods and services. Moreover, the appellant is not trading in the name Jigra, rather it is Messrs. Dharma Production Private Limited. Thus, the goods and services rendered by Dharma Production Private Limited by naming the movie Jigra cannot be said to be an infringement of trademark law. This is completely wrong, minutes. And this is minutes 1 day before the is to be released on that, and this is the order pass.
You have a registered trademark in which domain?
In class 41 minutes, which is the relevant minute. Just have a look at
class 41. What is class 41?
Class 41 includes. Just have a look at page D minutes, which includes all this, which includes everything. It's a domain minutes which is completely covering whatever they are doing. That's why they also moved under 41, which was objected to or not granted. Then what they did was they moved under 38. And in 38, they've been granted, which is for ad film, they've been granted.
This Dharma Production obtained trademark registration in class 935.
9/11/23 minutes. 9/11/23.
And at that point of time, your trademark was already.
Because my trademark is 15/6/22.
Now, before this trademark is issued or whatever you call it,
yes,
some objections are invited by the authority.
It has already been objected to. That has been mentioned in the. Just have a look at page 29.
Yes, Dr. Singhvi.
Can I just give me just 2 minutes? Jigra, the film, is put on posters in September 23.
What is, sorry?
This film, which is released 1 week ago, 4 days ago, is put on the posters and advertised across the country. 90 crore investment in September 23. Just note these few things. It's shocking, with great respect. My learned friend waits for 1 year. His whole case in the plaintiff, he does online education. In online education, he uses the word Jigra. Nothing to do with filmmaking, film production, movie, entertainment, nothing. Now, I advertised it 1 year ago, posters all over. 1 day before. Jigra, heart, very strong heart, somebody with a lot of courage. Courage. It comes from jigar. Not only heart, hearts can be soft. This is a very strong, courageous heart. Courageous.
Then September 23, you put it out.
He waits to come. He comes to the commercial trial court on 8th October after 1 year. He does not serve me. He makes a false statement that I've sent an email to Mr. Singhvi. Gets an ex parte order. I go to the High Court. In the appeal in the High Court, which he suppresses here, my appeal should be seen. I point out I never got an email. Your Lordship's commercial court requires an email. And he also suppresses that his certificate, of course, is at page 27 for education. What he suppresses is in my appeal at page 24, I am for motion pictures. Now the question Justice Pardiwala asked, just see the three entries. That is always an overlap.
What is class?
Yeah, just see this. Give it up. Give it to him. Just see the three reproduced here. And Your Lordship will understand. These are the normal slight overlaps which he is exploiting. Now I have just come to number 6. Look at how people are really actually pressurizing me or trying to extract. 6 Your Lordship has got?
This is item.
Item 6 my Lord has got?
Yeah, that is yours.
9, this is mine. Apparatus, instruments, recording, transmitting, reproducing, processing sound, I have got. I have got a registration. 35. Goods and services are next, I have got. 38.
Motion pictures is this.
Now 38 is most important.
No, clause 35.
35 is goods and services as annexed. Annexed is motion pictures. I'm sorry. This as annexed, which he suppresses at page 24 of my appeal, is this goods and services as annexed. Entry 35 is motion pictures. My registration certificate he suppresses here.
Okay.
Now 38 again I have wireless broadcasting radio.
Now when is his?
He has none of these. Now he's in 1 minute, sir. He's in 41. Come to the next one. Where he's in education, training,
entertainment.
Now word entertainment is there, so he says I can stop all free word jigra.
When you have a specific registration for wireless
9, 35 and 38.
Transmission of data.
35 and 38. Now see my registration.
Just my friend is not correct.
Just finish, please.
Just
see my registration of motion pictures. Can you give it over?
It doesn't annex it.
He suppresses.
Yes, my friend should say 35, whether it's covered under 35 or not.
Let me finish.
35, 38.
Now this
35, 38 is not for that class at all.
Which consumer?
His thing is released as a consequence of the para 9 of the High Court order. The High Court order is completely wrong.
How can we now stop? It's already out in the public domain.
My difficulty is that High Court could have rated for my evidence.
Assuming you are right, you can now have your claim will sound in damage.
They will come to the High Court and say now it has been what your Lordship was saying. They will say the same thing before the High Court also. That it is infructuous now. Go to the trial court.
They are not saying this. You are the one who came.
No, of course they will say this is the same thing. This is their.
How is it possible for a student in online classes to confuse a movie jigra with jigar education?
Let's kindly just have a look at.
Is it true that what you are doing is, to run online classes?
This what happens in an online class, my friend will also know. In an online class, what happens is there are videos which are created, which are sent overboard, which will have my.
But they have to be on education, no?
It is not just on that. Let's kindly just see. Just come to page 29 first. Just have a look at page 29 first.
Item 40.
Kindly just have a look at page 29. One moment. Just have a look at page.
We're not going to interfere at this.
Have a look at for my satisfaction. Please have a look at page 29.
No, we're not. We told you that the movie is released. You're not going to now.
Kindly just do one thing then.
Yes.
The matter is going to be taken up before the High Court. Let the High Court then decide the matter and not decide on the basis that there is infructuous. They will argue that this is infructuous again.
It can't be decided now. He can claim damages.
The Lordship has said, because the High Court in para 9 has clearly said, it has said all three parameters.
You can record your statement that since the matter is about to come to the High Court, you're withdrawing this. That we can permit you to do.
And then it will be decided on merits.
No, that we will say that since you want the matters.
My problem is that they will argue that it is infructuous.
He is withdrawing.
This is
withdrawing.
I will suffer both ways, but it's.
Thank you, Nigel. Item 41, yes.
Item 41, your Lord. MBBS admission matter, my Lord. Very, very limited prior to consider, my Lord, Annexure P2, my Lord, for correction of my application.
You applied as a general category candidate. What can we do? You filled in the form as a
Correct,
denial. Now you
Lord.
want
That was a mistake happened on the part of the government agency, my lord, which I relied on for my application, Your Lordship.
not permitted today to change your category to Muslim from general.
Your Lordship, only
I think we'll not interfere. Yes, item 42.
In 40 minutes, Your Lordship may allow me to withdraw it.
All right, dismiss the program. Dr. Singhvi, 40 we are permitting dismissing and withdrawing. 42.
42. Section 9 proceedings, my lords.
You know, they have appointed an arbitrator.
My lords.
You know, the section 9 proceeding, thereafter parties engaged in mediation, 2 documents were executed. Ultimately, now an arbitrator has been appointed, you can argue everything before the arbitrator.
If my lords may consider one point, my lords. Post section 9, there was a settlement. There is a largely now between parties. When everybody was satisfied, even the respondents
signed that before the High Court. You argue that all that before the arbitrator. Now, not a case for us to interfere once in arbitrator.
But then this will set a bad precedent, my lords. Ganjam the procedure let down in the law, my lords. Section 21 is a mandatory
dispute between families. Let the arbitration go on. Item 43 and 46 now.
Obliged.
43, 44 and 46, not 45.
Yes.
46 I am appearing. I appear for 96 Willard's
yes.
petitioners. Mr. Gupta is appearing in item 43.
So, Millard, this is relating to, Millard, the recruitment of civil judges junior division.
You say that you got unusually low marks in the English essay.
That is 46, Willard. I believe in 43.
Millard, across the board,
46, everybody is saying the same thing.
Across the board, I'll give you, Lordship, one example of a person who has been given 0 for an English essay of a 2-hour paper, which the person wrote. Got 0, where, my lord, the person has given the law paper in English. In the law paper, my lord, is concerned, you can either give it in Hindi or English. She gave it in English. She has got 40.
And, my lords, there is no moderate
topic of essay. The essay was on what topic?
You know the topic?
Yeah. Well, there were which was the essay?
The 3 topics. Judges speaks through pen was a
Beg your pardon?
Judges speak through pen.
Judges speak through
pen. That was the first topic. So basically, we have a choice. There are 3 essays.
The other 2? The 2?
Other one was based on Rajasthan fairs and festivals, and one was on Chandrayaan. Although there is a choice, there are 6 essays. You can write on
any 3.
Yeah, not any 3 minutes.
Any one.
These are students from National Law School of India.
All right. What we'll do is we'll issue notice, and we'll ask them to produce before us the answer sheets. We'll
also press once they'll appear to have an independent committee to assess this.
All right. We'll issue notice. We'll issue notice and make it returnable on.
Process is starting.
We'll keep it on Monday.
The interview
we'll
will
keep it on Monday.
26th.
Liberty to serve the Registrar General of the High Court of Rajasthan, the first respondent, Dusty in addition.
And through email and all of them.
And through some of the sample. How many totally are you people?
I appear for 96 petitioners. Mr. Gupta is about 3.
19.
I am for 96.
The answer sheets in the English essay for those candidates who have been awarded 0 marks shall be
15 minutes. So it's not just.
In my case, my lord, the petitioners 1, 2, and 3 have got 4, 7, and 3.
Out of
English essay.
Out of
below 10 marks. Below 10 marks. Below 10 marks. Below 10 marks.
So what is happening is
5-0. And Millard, I have got
shall be kept present before, shall be produced in the court on the next day.
Can I only say let it be 15 because
10 we'll keep it.
People are missing out by 0.5 below. So I am also pressing the principle of moderate.
Below 15 marks. Okay, below 15. Below 15 marks.
I'm great. Are keeping it for Monday? I'm great. Plus 44. 44 wasn't called out. That's slightly different on
44.
Yes.
45 is different.
44 is different.
Oh, 44.
Yes. Plus 44. Because I am a blind candidate. I have scored 113.5 in the Rajasthan Judicial Service. There is no separate cutoff for the disabled category. That is why I am getting knocked off.
But there is a judgment of Justice Dela Trivedi.
So, that judgment will not apply for one reason, that the rule here, my lords, in a proviso, clearly envisages a separate class for disabled category, which was not the case in Justice Trivedi's. So, may issue notice because
we'll issue notice.
Monday, because otherwise the interviews have started. Yeah, Monday, it's possible. I'm grateful.
Koi order, Dusty वगैरह.
Dusty to standing counsel.
May please, Lordships.
Why have you come here under 32? You can go to the High Court.
They've already done that. As an officer of the court, I should mention that. My Lordships.
You have gone to the High Court.
They've concealed that fact. In fact, they concealed the fact. The office objections was raised as to.
1 second. You've gone to the High Court, right?
With regard to the anticipatory bail, that has come to your lordship.
All the relief which you seek here, your relief is quash the FIR.
Your lordships.
Direct the state of Karnataka to register an FIR against the police officer was found prima facie responsible.
The reason
for compensation. You can move the High Court and all these.
Reason why I'm coming to your lordships is at page 65. If your lordships.
What is that reason?
That is the report of the Karnataka State Human Rights Commission, your lordships. The entire system, it has found that the police has not even issued 41A notices. I am shown absconding.
Miss Makira, the High Court, Karnataka High Court, the seasoned judges, then the bench is available.
Definitely, your lordships. It's not that I don't have faith in the High Court. The issue
and
that
because for quashing, we quite see sometimes people come here, protection against arrest, etc. Unless you pass an order, then it will be infected.
if I just
Washing and other things, you have to move the High Court.
if I just show the FIR, lordships will smell the putrid.
Court judges will also smell the same.
Your lordships, give me indulgence only for a second.
Anticipatory.
Yes, your lordship. Will not anticipate regular bail.
Regular bail.
Yes, your
You
lordship.
were arrested.
I surrendered and my anticipatory was dismissed. I surrendered and
These
got
which have been sought in the proceedings under Article 32 of the Constitution can well be
the lordships may then allow me to withdraw and file there.
with liberty to adopt appropriate proceedings in accordance with law.
They've already withdrawn it, Your Lordship. The petition was filed, they've already withdrawn that.
All right.
High Court, under the same grounds itself, my Lordship, have a look at that. That's what precisely I'm trying to tell you.
They have withdrawn the proceeding before the High Court.
Please, the Lordships, that's precisely the thing.
That must have been because of this petition.
In fact, we get more of a petition of which, okay, they've concealed. The office of objection was raised by this honorable court.
Yeah.
Charge sheet has been filed.
What my learned friend is talking about. Seek instructions on it. Because this.
My Lordships may have a look at this. The office objections that are raised by this honorable court, they gave a letter of clarification that why is it that.
How many prosecutions are there against this man?
Only
My
one.
Lordships, he's been
Six against him, including three.
Who is the first informed?
My Lordships, I am the complainant as.
Who are you?
I'm the complainant, Your Lordship, as far as this case affair is concerned. He's been convicted by his main allegation against High Court judges of.
I'm withdrawing.
Just say with liberty to adopt appropriate proceedings in accordance with law.
Honorable High Court. Very well. Great.
Item 47.
The Lordship's permission.
Because here the matters worked itself out. The judicial member is continued for 2 years, my lord, after your Lordship's order.
Who are you?
I'm the tribunal, my lords. The registrar of the tribunal, administrative tribunal. I have instructions from the chairman. The pendency has come down from 10,000 cases to just 1,500 to 2,000 cases in the principal bench. And this Narayan Swami, who was continued by your Lordship's order, has now retired, has crossed 67 years.
Now, what is the total constitution of the tribunal today?
My lords, today the chairman, there's another judicial member in the principal
no other judicial member.
Bangalore. There's one judge, my lord.
Is there any other judicial member?
Yes, the chairman and Mr. Watwati, who's another judicial member.
Have you filed an application here?
Yes, an affidavit and application, both.
Lord, may I just submit one thing, my lord, if your Lordships permit me?
Yeah.
My lord, during the pendency of this, my lord, the Karnataka Administrative Tribunal, my lord, has benches in Dharwad and, my lord, in Bangalore, my lord. My lord, in Dharwad there is one judicial member, my lord, and in the Bangalore bench, my lord, there is one chairman, my lord. The other judicial member, as my friend rightly pointed out, my lord, he has crossed 67 years. He has been granted 1 month extension about a week ago, my lord.
Even your Lordships, when the order is...
to give us, we keep it on Monday. Why don't you give us a small statement just of the entire tribunal, what benches, Dharwad, and And so far as Mr. Mahale is appearing for that member, right?
No, my lord, I am not appearing for the member.
He is for the advocates.
Yes.
And now, therefore, you are saying that this man's now tenure has to come to an end.
It's already by virtue of a law.
And the interim order has to come to an end.
Absolutely.
Yes.
This vacancy has also been filled up, my lords.
No, it is not filled up, my lord.
It has been filled up, my lords. We are carrying a chart. If your lordships would like to see, my colleague will hand it over, my lords.
Let's see that.
Yes, my lords. My lords.
10th October 2022, when your lordships continued the tenure of the member, it was under the circumstances that the tribunal will become defunct because there is no judicial member.
Yes.
Subsequently, judicial member has been appointed, my lord, and this honorable member whose tenure is being continued, he has attained 67.5 years. Now he has almost reached the
the interim order of this court dated
10th
October 2022 was passed in a situation where, in the absence of a judicial member, the functioning of the Karnataka Administrative Tribunal was liable to be dislocated. Full stop. It is common ground that since then, judicial members have been appointed.
Only one judicial member, my lord. Lord, only one out of 3 vacancies, only one has been appointed, my lord.
Judicial member has been appointed.
That is in Dharwad.
The judicial member has been appointed. Full stop.
In Dharwad bench.
The judicial member who was protected by the judicial member, what's his name?
Narayan Swamy, T. Narayan Swamy.
T. Narayan Swamy, who was directed to be continued by the interim order of this court, has since attained the age of 67 years. Full stop. The interim order, insofar as Shri T. Narayan Swamy is concerned, shall consequently stand vacated.
Grateful.
Full stop.
Would your lordships give me 1 minute?
Have to be filled in by the Union of
The
India.
process is going on, my lord. We have the appointment committee is considering it. Because of this interim order, there was a bit of
the appointment committee is of
the
In the state, before the High Court, there's a committee.
All steps shall be taken expeditiously for completing
Give me 1 minute.
the tribunal without any further delay.
Would your lordships give me just 1 minute, my lord?
But Mr. Mahale, you have continued for
No,
2 years.
Lord, I am not appearing for the interim order was not in favor of.
But lawyers also have no vested interest in that man continuing.
No, I am not.
May it please, my lord. The lordships have already issued notice in this.
My apologies for not being able to present in court and assist the court, Your Lordship.
My lord, this is that short service commission, my lord, for women. By a judgment, my lord, which your lordships will find, my lords, at February 26, 24.
But you are denied short service commission.
Yes, my lord. And then, my lord, they passed an order, which your lordships will find at page 28. After 15 years of service, my lord, 2 extensions. Now, my lord, a ground is taken that I am not suitable. Kindly see, my lord, I was appointed in 2007.
Just produce the records before us. We'd like to see the records on Monday.
Monday, my lord.
Monday.
Yes, that can be done. Somebody will assist the court on Monday. The record, see the records. I've also seen the records.
Shall produce before this court the original records pertaining to the consideration of the candidature of the petitioner for the grant of permanent
commission.
List on swans.
But all this has started, my lord, after I made that sexual harassment complaint.
Your
lordships will see that, my lord, from the record.
My apologies, my lords. My lords, Leonard ASG, Mr. N. Venkatama requested if it can be kept on Friday. He is still held up.
It's just a matter for one line, that's what we require, my lord.
Can he come on Monday? We can take it up on Monday because Mr. Ranjit Kumar is constantly here, you know. We don't want to embarrass the learned ASG, but we can take it up on Monday if you don't mind. Unless he is not in town on Monday, then we don't.
He has specifically requested for Friday, my lords.
But is he in Delhi on Monday?
He might. He is in personal difficulty on Monday, but he has requested for Friday.
He's not in court on Monday.
We have to check it up.
All right, what we'll do is this. You just talk to Mr. Venkatraman.
Yes.
If Monday is fine with him, but if Monday is fine with him, we'll take it up on Monday. In case Mr. Ranjit Kumar sees them personal difficulty, we'll take it.
Your lordship give, my lord, because it is affecting other resolutions.
All right.
My lord, there are 2 companies.
But Monday is fine.
Monday is fine. Monday is fine. So we'll take it up on Monday, no difficulty.
Very great.
But now, if he is not in town for some personal reason, just tell Mr. Ranjit Kumar and tell my court master. He is always very kind.
That's Monday, otherwise Friday.
Monday we'll take it up.
May I mention item 42, my lords, that arbitration matter, if my lords may keep all the issues open, because High Court has already given an observation that 21 notice is not required, and then you can proceed with
all the rights and contentions of the parties before the arbitral tribunal are kept open.
Obliged, my lords.